I call the Honourable Rick Barker.
Mr Chairman, I've got 2 points that I'd like to raise, 2 questions to the Minister and the Chair. And he's a member of this House is very knowledgeable on the law. And the first one that I'd like to ask the Minister to make some comment on is on Clause 45 of Part 3. And I've always had this belief that the heading should be completely and entirely consistent with the substance of it. And the heading of Clause 45 says that a trustee or statutory supervisor must report a breach or possible breach of an issue or obligation. But when one gets into the text of it, it has an important qualifier, and that is reasonable grounds to believe. Now, reporting a breach and reporting a breach where you have reasonable grounds to believe are two different things. And I want the Minister to explain to us if the courts or some other institution comes to interpret this clause in the future, whether it will be guided by the must without a qualification, the heading, or whether it will be guided by the reasonable grounds. So I just want to say to the Minister that there appears to me to be a slight inconsistency there. One could argue that the heading is simply to set out the broad terms and all of the qualifications are put underneath it, but the heading is a very bald statement. The second part I'd like the Minister to comment on, and I was interested to read Clause 48. And Clause 48 is quite a powerful clause. In Part 1, it says, without qualification, no civil, criminal or disciplinary proceedings may be brought against a trustee or statutory supervisor in respect of a protected disclosure. Now, it doesn't say what the protected disclosure is in regard to. So if a member makes a protected disclosure, does that mean that the person is therefore immune from any civil or criminal prosecution? So if the member has, according to this statute, made a protected disclosure, then no civil or criminal disciplinary proceedings may be brought against that particular trustee. Now, if it was qualified that the protected disclosure, the civil or criminal proceedings, were limited to within the ambit of the protected disclosure, which was pertaining particularly to this legislation, I would say fair enough. But that's not what the law says. It simply says that no civil or criminal prosecution may be brought against the member. So these, I think, are quite sweeping powers, and I wouldn't want a court later to interpret, well, Parliament must have known what it said when it said no criminal or civil proceedings may be brought against a person who has a protected disclosure. If it was Parliament intended there to be a qualification, well, then I think it should have said so. But there is no qualification in this particular clause. And I think the Minister and the Chair should dwell on that and offer to the House some commentary, because after all, when it comes to interpreting legislation, it's not unknown for the courts to go back and look at the record of the Hansard to see what Parliament meant. And if the Minister was to make a clear statement about both of those issues, I'm sure that there's a possibility in the future that they would be referred to and his learned words would be well sought by the court. So I look forward to the Minister's response.
I call the Honourable Minister Simon Carr.
Now there's the voice of experience, understanding how the committee stages are supposed to work clause by clause, getting into the detail of some of these things. I could reassure the member in respect of his second, and of course I couldn't help myself, as the member would know, that when questions like that are put, I've got to rise to my feet and delay this thing even further than I'd like. But the challenge is the challenge, right? So clause 48, if the member had dropped his eyes to subclause 4, he would see that the nature of protected disclosure is defined in that clause. Just flicking back to clause 45, the member raises an interesting point here, because as I understand it, amendments to the Interpretation Act do take into account the heading in a clause or a section, whereas previously that was not the case. It was only the substantive matter in the clause that the courts paid any attention to. Having said that, this clause actually makes it very clear that if the grounds are met, that is, that the reasonable belief is held, then the trustee or supervisor must, as soon as practicable, make the report. So the matters contained in the heading to clause 45 are in fact a brief summary of what's actually included in the substantive part of clause 45. I thought you might.
The question is that the Minister's amendments set out on SOP number 223 be agreed to? As many of that opinion will please say aye. Aye. Contrary, no. The ayes have it. The question is Part 3 as amended. Stand part. All those in favour please say aye. Aye. The contrary, no. The ayes have it. The question now is that Part 4, debate on clauses 51 to 90, stand part. The question is that the Minister's amendments set out on SOP number 223 be agreed to. As many of that opinion please say aye. The contrary, no. The ayes have it. The question is that Part 4 as amended stand part. All those in favour please say aye. The contrary, no. The ayes have it. The question now is that Clause 1 and 2 stand part. The question is that Clause 1 stand part. All those in favour please say aye. The contrary, no. The ayes have it. The question now is that the Minister's amendments set out on SOP number 223 stand part. All those in favour please say aye. Contrary, no. The ayes have it. The question now is that Clause 2 as amended stand part. All those in favour please say aye. Contrary, no. The ayes have it. I will report this bill with amendment.
Members, the House is resumed.
Mr. Speaker.
Mr. Chairman.
Mr. Speaker, the committee has considered the Legal Services Bill and reports it without amendment. The committee has considered the Financial Markets, Regulators and KiwiSaver Bill, reports it with amendment and divided into the following bills. Financial Markets Authority Bill. Securities Amendment Bill number 3. Securities Markets Amendment Bill number 2. KiwiSaver Amendment Bill. Financial Advisors Amendment Bill number 3. The committee reports the Securities, Trustees and Statutory Supervisors Bill with amendment. Mr. Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Contrary, no. The ayes have it. The Legal Services Bill, the Financial Markets Authority Bill, Securities Amendment Bill number 3, Securities Markets Amendment Bill number 2, KiwiSaver Amendment Bill, Financial Advisors Amendment Bill number 3, and the Securities Trustees and Statutory Supervisors Bill are set down for third reading next sitting day. Call on Government Order of the Day.